Thank you, sir, for giving me this opportunity. Uh, in one line, the answer to that is fewer number of judges. But going into the background, the Islamabad High Court has adopted the Lahore High Court rules and orders. And in the Lahore High Court, initially, like the other high courts, the writ petitions used to be heard by division benches. And it was realized that too many judges are occupied deciding cases which can easily be dealt with by a single member bench. So therefore, a decision was taken for writ petitions to be heard by single benches and for the provisions of the law reforms ordinance to be made applicable and for there to be inter-court appeals. I do understand that it is time consuming and there are two rungs of the ladder in the same high court that you have to climb before you go to the Supreme Court for a decision on a matter. But the Section 3 of the Law Reforms Ordinance, after all, gives a very valuable right of appeal. It's a substantive right. There are also examples where judges sitting in the division bench set aside, and for good reason, the judgments passed by a single bench. This idea did cross our mind, and we sitting amongst peers sometimes have a degree of discomfort when we set aside the judgments of our brother judges. But this is something that we have to become immune to. This immunity is something that you have to acquire, and if you feel that the judgment merits setting aside, you should not hesitate in doing that, because after all, you have to uphold the principles of law. But the reason why we came to the conclusion that this should not happen in the Islamabad High Court is because of the sheer volume of cases. We are 8 judges and our backlog is 17,000. It is not humanly possible for us to adjudicate so many cases with such a small manpower. So therefore, there were certain cases which used to be heard by a division bench, like for example, the bails under the Control of Narcotic Substances Act. There, the administration committee took a decision for those cases to be now heard by a single bench. The entire rubric of this conference is alternative dispute resolution as a method of curtailing and reducing the burden of the courts. We in Islamabad Capital Territory have the Alternative Dispute Resolution Act of 2017. But the act was enacted, it did not precipitate amongst the litigants as well as the judges until a number of years. We were given a wake-up call by none other than the Legal Aid Society when they told us about this act and also wanted us to study the model in Turkey, where this law came in 2013 and had been a success story over there, in that more than 3 million cases had been decided through the process of mediation. In 2018, the mediation rules have been made in order to amplify this concept of dispute settlement. The foundational aspect of this concept in the ADR Act of Islamabad is the concept of consent. On the first date of hearing, the adjudicating officer, whether it's the High Court in original jurisdiction or the civil courts, have to give the option to the parties whether they want to resolve their disputes through consent. We, in order to make this process of mediation more robust in Islamabad, have issued practice directions to the judges. Initially, there was a degree of reluctance amongst the subordinate judiciary to go for this or to cause parties to agree to mediation. But we in the administration committee have now decided that the judges of the district judiciary, for a contested case, they get certain points. So if there is a successful referral to mediation and that results in a settlement, they will get the points of a contested case. This should be an impetus for them to refer matters to mediation. From the data that we have been given, Islamabad is divided into 2 districts. There is District East and West. In District East, the courts have referred 73 cases to mediation. Out of them, 29 have completed, 10 have been successful, and 19 have been unsuccessful. Now, this figure is not discouraging at all because it's the beginning. It's the beginning. And it is all very well for mediation not to be successful as long as the parties make an earnest effort to settle their dispute out of court instead of resorting to litigation. The regime that Pakistan has for the enforcement of foreign arbitral awards, the answer to that is yes. We have it in the form of the recognition and enforcement of Foreign Arbitral Awards Act of 2011. It was preceded by as many as, I believe, 8 ordinances commencing from the year 2005. And it is in recognition of Pakistan's obligations under the New York Convention of 1958, to which Pakistan became a signatory in 1958. But it took several years for the process of domesticization to take place, because the mere fact that Pakistan has become a signatory to a treaty does not make it a part of the laws of Pakistan unless legislation on the basis of that treaty is made, incorporating it into the law of Pakistan. The schedule to the 2011 Act is the New York Convention, and there's a provision in the Act giving it primacy over the provisions of the 2011 Act. When there is a foreign arbitral award as defined in the 2011 Act, the High Court has the exclusive jurisdiction where an application can be filed for its enforcement. The party against whom the enforcement is to take place has been given the option to resist its enforcement by filing objections. Those objections have to be restricted to the objections which are enumerated in Article 5 of the New York Convention. The objections, as we commonly know, under Section 30 of the Arbitration Act 1940 do not apply here. You have to look at the case with an extremely narrow spectrum. Whether an award can be challenged by courts in Pakistan is also to be determined in accordance with the law that governs not the substantive rights of the parties to the underlying contract, not the governing law of the agreement to arbitrate, but the governing law of the procedure for arbitration. So if the governing law of procedure for arbitration is specified in the arbitration clause, then it is in the courts of that country which governs the procedure for arbitration. Otherwise, it is the seat of arbitration, the courts of the seat of arbitration to which the challenge will lie. Courts in Pakistan, the Sindh High Court, Lahore High Court, the Islamabad High Court, there are now umpteen judgments where arbitration awards have been enforced. There are 2 judgments of the Honorable Supreme Court of Pakistan, where one of them upholding a decision to enforce a foreign arbitral award, another setting aside a decision of the Lahore High Court where intervention was made in a foreign arbitral award. So that is a welcome change and a breath of fresh air for economic stability in the country. The power under Article 199 of the Constitution is not a very wide power. It is circumscribed. And that parameter for the exercise of that jurisdiction has been laid in judicial precedents from the High Courts as well as the Supreme Courts. As far as the parameters of mandamus are concerned, that are very well enunciated in Article 199. You will issue a command to the government to do what it is supposed to do under the law, prohibit it from what it is not supposed to do under the law. But now that we have the judgment of Sophia Wakar, it has taken away the jurisdiction of the High Courts to exercise suo motu jurisdiction. Why I say taken away is because earlier there were cases where the High Courts did exercise this suo motu jurisdiction, and the exercise of that jurisdiction was most conducive to the rule of law and for the system of governance. I recall in 1999, the Honorable Mr. Justice Ajmal Mia writing in a judgment saying that whether Article 199 gives the High Courts the power to suo motu exercise jurisdiction is a very debatable point, and we need to delve into it very deeply. You would, if going through the Sophia Wakar case, you will see that it deals with the matter extremely in a cursory manner. There is no in-depth analysis of this jurisdiction. So I would urge the Honorable Supreme Court at an opportune juncture to readdress this issue by not bearing in mind that some of us are trigger happy and would venture into jurisdictions where we are not supposed to. Give us the benefit of the doubt. And in India as well as Pakistan, the exercise of this jurisdiction has been extremely conducive. Don't just leave it to the Supreme Court. Share that jurisdiction with us.